So I want to talk a little bit about a really effective drug driving defence that we use to avoid convictions in drug driving cases. And we use this defence in all drug driving cases, but we tend to deal more so with THC cases, cocaine cases, and benzo cases, because those are the three most common that the prosecution will charge for. Now, how this defence works, it relates to the forensic evidence that the prosecution have to provide in a drug driving case when you choose to challenge it. At the very early stages of a drug driving case, you receive what's called an SFR1. The process by which the prosecution introduced forensic evidence in a criminal case changed quite recently with the introduction of what's called the Streamlined Forensic Reporting Protocol. And the idea behind this new protocol was that it cuts costs for the prosecution when relying on forensic evidence, blood samples, urine samples in criminal cases. And it's a two-stage process, there's two parts to it. So at some stage in this case, you'll receive what's called an SFR1. That's a very basic short-form expert report. It won't tell you much about your drug driving sample, the drug driving case. It will just tell you the results of the charge. Now, it's all designed to look very official, probably to make you think you're guilty of the offence, and it's anywhere from 1 page to 3 pages. If you look at the front of the SFR1, there's a little bit more information about what an SFR1 actually is. Is it evidence? Is it admissible? Is it an expert report? Can it be used in court? And if you look very closely, you might see in bold text, 14 days. That's because you have typically 14 days or 10 working days to respond and agree or respond and reject the SFR1 document. Now, if you agree the SFR1, then the results are simply entered into evidence, and it's assumed that you're not then going to challenge the SFR1, you're not going to challenge the blood results. That doesn't mean to say you can't challenge other parts of the prosecution's case, but they know then that you're not challenging those results. If you reject the SFR1, and for obvious reasons I spend a lot of time rejecting SFR1 documents for the clients that I represent, then it means that the prosecution can't rely on that short form report, and it also means that we're not accepting the results that the prosecution have come back with. Now, some of the most common ways for rejecting the SFR1 might be the length of time it's taken for the case to reach court, which would usually indicate that your sample's been held in police custody for a lot longer than it should have been. Let's say it's been 10 weeks since you were first arrested and you only now had the results back. Well, that's a good indication that your sample's probably been held at the police station in completely inadequate or unsuitable storage conditions for a lot longer than it should have been, because there's certain police guidance that says send that sample to the lab within 1 week of that sample being taken. So you can reject the SFR1 for that reason. It might be that the result is not consistent with your consumption. So even where you accept, for example, consuming cannabis or cocaine, you can still reject the SFR1 on the basis that you don't accept the result. Let's say the result sounds too high for what you accept that you consumed. If you consumed cannabis 2 days ago, you wouldn't typically be over the legal limit 2 days later. But if the result puts you at twice the legal limit, you're entitled to say, I'm not accepting the result for that reason. Or it might be because you're simply entitled to challenge the prosecution's case, and you're allowed to see all the checks and the balances that should be carried out by a police laboratory in your case. You're allowed to see how they actually arrived at that result, how they got there, what equations and maths we use to generate that kind of result. So you can reject the SFR1 for various reasons, and again, I can explain that process to you. But once you reject the SFR1, it means the prosecution can't then use it. So how do they prove that you are over the legal limit if the only forensic evidence that they had at that stage, the SFR1, is now inadmissible, in other words, can't be used, because you formally rejected it within 14 days? Well, it's what's called an SFR2. It's a more detailed forensic report the prosecution have to come up with. I'll put a copy of a front page of an SFR2 up there so you can see, and that's what an SFR1 looks like as well. So you can compare the two. They look very similar. The difference is the SFR2 is a Section 9 written statement, and you'll see the Section 9, you should see a Section 9 declaration at the start of the SFR2 or at the top of the SFR2 that will mention that this is a statement pursuant to Section 9 of the Criminal Justice Act. But it's also a more detailed expert report as well. So it should tell you a lot more about how the sample was stored, how it was handled, how it was preserved, how it was analysed, and how they arrived at that result. You can even go as far as to ask for the names, the qualifications, the level of experience of every person involved in the testing of your sample. And that's well worth doing in my view, because in a lot of the drug driving cases that we deal with, when we get the list of, let's say there's 8 or 9 people involved in the process, you'll often find that they have less than a year's experience experience, and very few have qualifications that actually relate to forensic science. So is that a reliable reading if it's a result that's generated by somebody with less experience, where perhaps a mistake could have been made? So you're certainly allowed to ask for that information. Now, in order to run this defence, you have to understand Part 19 of the Criminal Procedure Rules. I'll link a copy in the description of the video, and the front page of the Part 19 Criminal Procedure Rules looks something like this. So you can skip to it, you'll see Part 19, Expert Evidence, and that's because any forensic evidence that relates to a blood sample is considered expert evidence in a criminal case. Now, what Part 19 tells us, very, very briefly, is that the prosecution should serve forensic evidence as soon as practicable, following what would be a not guilty plea or the point at which you reject the SFR1. They should serve the SFR2, and they should serve the analytical data pack, that's all the raw technical data relating to the testing of your blood sample, as soon as practicable following a not guilty plea. Now, do you think in most of these cases the prosecution serve forensic evidence, their SFR2, as soon as practicable? No. In most cases, they don't. And often the case goes on and on and on, and it could be many months until the prosecution finally come up with the SFR2 and the analytical data pack. In many cases, it's very close to a final trial date that the prosecution will eventually come up with the forensic evidence that it should have served, sometimes many months ago. And the reason they'll give for not complying is because labs are overworked at the moment. There's lots of requests for SFR2 documents they can't keep up, and that's the reason for the delay. But the point is, if you don't receive the SFR2 and the data pack in time, it wasn't served as soon as practicable. It's worth checking the date of the SFR2, because sometimes you'll see that the date is much earlier than when they eventually served that document, so it might be that they've had it in their possession for a lot longer than they should have done and only eventually served it closer to a trial date. But what Part 19 says, if it's not served as soon as practicable, then the starting point is that the evidence should not be admissible unless both parties agree, which in most cases we don't, or the judge chooses to admit it. And so the prosecution should make an application to the judge or the magistrates in the magistrates court and ask them to admit the forensic evidence. But what I will then ask the judge is, first of all, why the prosecution didn't comply. Have they explained the delay? And also why they didn't apply for an extension under Part 19.10 the Criminal Procedure Rules as well. You'll see that up there. They have to apply for an extension if they're not going to comply with the court direction. And the wording is that they must apply for an extension, they must explain the delay. So in most cases, they're not able to explain the delay. They haven't even applied for an extension of time. And the starting point there is that the evidence should not be admissible. And out of all the drug driving cases that we win, I'd probably guess around 70% of those cases we win on that particular point alone. So there's a way of setting the case up properly so you can argue these disclosure arguments at a later stage in the case. There's still a requirement on the defence to chase the prosecution. We have a responsibility under the criminal procedure rules as well to chase the prosecution, to ask for the evidence, to remind them to serve it. Of course, in most of these cases, those requests go ignored and the prosecution still don't comply. So I'm happy to explain how this defence works in your particular case, how we go about trying to argue that the evidence shouldn't be admissible, particularly the forensic evidence, and how you can win the drug driving case on that basis.